in the HSE and manager of the National Open Disclosure Office, and you're all very welcome to today's webinar. When in a very timely way, we're going to be talking about the Patient Safety Bill and the National Open Disclosure Policy Framework. And when I say timely, it's really in relation to the recent enactment of the Patient Safety Notifiable Incidents and Open Disclosure Act on the 2nd of May this year. So we're very fortunate, and we welcome our colleagues from the Department of Health here today from the National Patient Safety Office, and they will introduce themselves to you in a couple of moments. I'm also joined here by the Open Disclosure team, by the Assistant National Director for Incident Management, and also we will be joined later by Dr. Orla Healy, the National Clinical Director for Quality and Patient Safety in the HSE. So just before we get into the presentation, just to go through some general housekeeping. So just to say that while the presentation is running, you'll all be muted and you'll remain muted throughout the webinar. But please do engage with us through the chat function, introducing yourself, where you're from. But also, if you do have any questions for our panel, we will take those questions at the end of the presentations. Just to let everybody know that this session today is being recorded, and this recording will be made available for everybody on the Open Disclosure website as usual. And just in relation to sound, if you're having any sound difficulties, you can dial in there through the number on the screen, and that number will be available for you in the chat function as well. Just to let you all know that we do have some CPD for today's webinar, and 2 CPD points from the RCPI and 2 CEUs from NIMBY. And this accreditation applies to attending the live webinar only. And we can provide certificates to you. Just email the Open Disclosure Office on opendisclosure.office@hse.ie, and we'll be delighted to send out your certificate to you. Just in relation to additional supports today, we have Lisa Harvey with us today, who you'll see on the screen. Just Lisa is an ISL interpreter, and you'll see her just providing the ISL throughout the full webinar, and that will be available on the recording as well. There is also a closed captions option, and that's really text that will appear on your screen to reflect what's being said. And you'll see the little box on the bottom left of your screen. If you click on that box, you'll see that the closed captions will activate for you. So it's up to every individual person to actually turn that on if they want it. So just now to introduce our guest speakers for today, I'm going to hand you over to Maurice O'Donnell, Principal Officer from the National Patient Safety Office in the Department of Health. And just to say thank you again to Maurice and his team for coming on here today. And, you know, with very short notice, we thought it was really important to have this presentation now with the enactment of the bill. So thank you to Maurice, Susan, Liam, Arnell and Stephen from the office. And I'm going to hand over to yourself now, Maurice. So I'll stop sharing here.
Thanks very much, Angela. And it's great to have the opportunity to talk to everyone today. I'm just keeping one eye on the chat box, and it's fantastic to see people from so many different parts of the service and different parts of the country being able to tune in. So that's excellent. I am the head of the Patient Safety Legislation, Policy and Advocacy Unit in the Department of Health. And as Angela mentioned, it's actually very timely that this webinar is taking place today, because I suppose there's two major developments. The first one is that finally, after a number of years, and you'll see this in the presentation, how long the journey was, but after a number of years, the Patient Safety Act, it's now an act. It has been enacted by the President at the start of May, so it is now law. It will need to go on and be commenced to actually take effect, but it is actually on the statute books now. So that's the first thing. The second bit is our open disclosure framework, which we'll also be talking about today. And that's been developed over the last couple of years, and that will be launched at the end of the summer by the Minister, hopefully involving a lot of yourselves from the HSE too. What we're going to do today is go through a short presentation on both of those things. Starting off, two of my colleagues, Susan and Liam, will talk about the Patient Safety Act, give a little bit of its background, and I suppose how it has developed since we would have been last talking to you. And after that, two other colleagues from the office, Arnell and Stephen, will talk about the open disclosure framework, which is, I suppose, the overarching policy piece to kind of set out a standardized approach to open disclosure policy across the health sector. I'm going to stop talking very shortly. I'm going to hand over to Liam and Susan. I will come back after the two presentations and we'll do just a little bit of a wrap up, and we'll be open for any questions that you might have. But I suppose just the final thing to say before we get into it, it's worth bearing in mind the two separate pieces really are, we would view as both sides of the same coin. The legislative piece and the policy piece, both of them, I suppose, are aimed, the ultimate aim is cultural change, moving towards a culture of more openness and more transparency, moving towards some of the ideas, I suppose, that we hear bandied around of a just culture, moving away from the blame culture of things to a space where if something does go wrong, people can talk openly about it, can give patients the information that they need, sort of without kind of fear of the blame culture and fingers being pointed. I hope you'll see how both of the pieces go about doing that. But look, with that, I'm going to stop talking. I'm going to share the presentation, but I think we're going to start off with Liam and Susan talking about the Patient Safety Act now. So I'm just going to mute myself. Thanks very much.
Okay. Hello, everybody. Lee McCormick here. So I work in the area with Morris, and I worked on the bill for the last 12 to 14 months. So essentially, my intention is just to give you a brief overview of the actual act itself and some of its provisions. It'll be quite a superficial summary given the time available, but one area maybe that's always helpful when looking at acts is the long title of the act itself. So I'll go through that in a little bit more detail in a second. So firstly, the background to the development of the Patient Safety Act 2023, and up pop the three boxes there. You're already aware there is the Civil Liability Amendment Act 2017, which was voluntary open disclosure of patient safety incidents as things currently stand, which can be the basis for the disclosure of information in relation to patient safety incidents that have occurred. This was kind of a bill that was, or an act that was mixed up with other kind of more other information, other things to do with amendments to the Taxes Act and other subject matter. You'll often find that with acts, in that what happens is that if there's something to be done and it needs to be done relatively quickly, it could be tagged on with another act that's going through the Oireachtas at the time, just simply for the purposes of administrative expediency. So the Civil Liability Amendment Act anyway was tagged on with other provisions that exist in that act itself. So that led on then to our Patient Safety Notifiable Patient Safety Incidents Bill 2019. It's got its first airing in the Oireachtas. When I say the Oireachtas, of course, you know I mean the Dáil. We started in the Dáil with that in 2019. And ultimately, it took from 2019 right through until 2023 to actually have it enacted and passed by the Oireachtas and signed by the President on the 2nd of May last. Now, look, it wasn't anything to do with our delay. That it took 4 years to get from the stage of the bill in 2019 to enact in 2023. There were other things in between. As you can imagine, in 2020, we had a change of government. And of course, then we had COVID, when all hell broke loose, I suppose, and all of us and many of us were working in emergency mode for a while. And then also, I suppose, really, there were amendments to be made to the Act as well, which Susan shall talk about later. One was a pretty heavy structural amendment that had to be done at report stage in the Dáil back on between December and February of 2023. So next slide, please. So ultimately, it provides for a number or a legislative framework for a number of important patient safety issues, including mandatory open disclosure of a list of specified serious patient safety incidents that must be disclosed to the patient. If I kind of look at the long title there, really the Act talks about mandatory open disclosure by health service providers of certain incidents occurring in the course of the provision to a person of a health service. And the Act then provides for definitions of many of those terms, such as, for example, what is a health service, what is a patient, what is a health services provider. It then goes through, certain restrictions on the use of the information provided in such disclosures. It talks also about Part 5 reviews, which was the structural change that we ended up having to make to the bill in December to do with patient requested reviews of cancer screening services provided. Clinical audit is covered then as well within Part 6 there. And then there's amendment to various acts, including the 2007 Act, to provide for the extension of HICRA's remit to private hospitals and certain patient safety incidents that can occur in nursing homes as a result of a review of how things happened during COVID. Just to say then at the end as well, in line with a lot of acts, there's schedules at the end of the acts. This provides just a space in which, if you're referring to particular things throughout the Act, then you provide maybe for it in a schedule for ease of reference. So we have a Schedule 1 and a Schedule 2, and Schedule 1 has a list of the defined most serious patient safety incidents to be governed by mandatory open disclosure within the Act itself. So the big difference maybe to view it from the 2017 Act is probably really in the words that you use to describe what has to be done. I suppose that the 2017 Act, Part 4 of the 2017 Act, calling for open disclosure or providing for open disclosure, that always is peppered with the word may, which means voluntary in legal parlance. Whereas within the Patient Safety Notifiable Incidents and Open Disclosure Act 2023, it's peppered with the word shall, which introduces the mandatory element into the Act for the open disclosure of patient safety incidents. Okay, so next slide, please. So again, I talked about that, all right, Part 4 of the Civil Liability Amendment Act 2017, providing for open disclosure. And then just a slight background in the 2017 Act, when it was being passed through the door, that the Minister gave a commitment to progress legislation on the mandatory open disclosure for a defined set or list of serious events. Just to say as well that there is a Section 8 within the Act itself, which provides for the empowerment, I suppose, of the Minister to make regulations for the addition within given certain parameters of other patient safety incidents that are not already in the Schedule 1, Part 1 and 2 as things stand, which at the time we are seeing as probably the most serious incidents. All right, next slide, please. So the bill provides or forms part of a broader program of legislative and policy initiatives, including the Civil Liability Act 2017, that seek to embed a culture of open disclosure. The legislation was informed by the report of the Commission on Patient Safety and Quality Insurance, and the HSE Open Disclosure Policy 2013 laid the groundwork for open disclosure in the Irish Health Service. Next slide, please. So just from a legislative point of view, many of us weren't around at this time, but the paperwork provides more or less that the draft heads for the open disclosure and clinical audit were provided for in the general scheme of the Health Information and Patient Safety, or the HIPS bill, in November 2015. So the draft heads are just ultimately how you start writing a bill on legislation, in that you write a narrative in the form of draft heads of what you want the bill to do. And once that's approved by government, it goes over to the Office of Parliamentary Counsel, which contain all the barristers that do the legal drafting for you, who work in the Attorney General's office. And ultimately, it culminates in the publication of a bill. And that bill then really is what is refined and worked on from thereafter. So there was a government agreement then to separate the provisions for open disclosure and clinical audit from the HIPS bill. And they approved the general scheme of the Patient Safety Notifiable Patient Safety Incidents Bill 2019. That provided the legislative framework for a number of important patient safety issues, including, for the first time in Irish law, a legislative framework for the mandatory open disclosure of specified patient safety incidents. And again, just to say, like, covered within that, of course, was a part in the bill providing for the extension of HICWA's powers to private hospitals, but also for a provision for providing for reviews by HICWA of certain patient safety incidents that occur in nursing homes or dedicated centres. Next slide, please. So I spoke earlier just about why it took so long with the bill itself. I suppose really, you know, the certain procedures in emergency mode do allow for you getting a bill through the Oireachtas within 48 hours if required. Excuse me. Just slightly digressing, I worked previously writing, I was writing the COVID legislation, which was a weekly conveyor belt of legislation to be written, providing for the restrictions domestically and abroad and travel, etc. And essentially the basis for that was the 1947 Act, but that had to be amended back in March of 2020 to take account of COVID. And I suppose the whole purpose of that would be we got that Act through the Oireachtas within 48 hours, back to back in 2 days, simply because it was emergency mode and it was a national emergency because of the pandemic. So that, along probably with the change of government in 2020, did delay inevitably lots of programs of legislation that had been destined to go through the Oireachtas at the time. Just briefly, timelines: the general scheme of the bill, which is as described, containing the heads, which is just the narrative of what you want the bill to do, that is read by the barristers over there in the Office of Parliamentary Counsel. That was approved by government on the 5th of July 2018. Then there was pre-legislative scrutiny by the Oireachtas Committee on Health on the 26th of September 2019. That's where the democratic representatives of the people, I suppose, really, who are on the Committee of Health, get their first chance to do some detailed scrutiny of it and request amendments to just the general scheme or the heads of the bill. So government approved text and authorised minister to introduce into Dáil Éireann. That was the 3rd of December 2019. So it progressed through the first and second stages on the 12th of December 2019, and Dáil Committee stage on March of 2022. We'll explain the difference between those just briefly later on, but essentially the second stage is where the minister gets to talk about the bill, and the opposition can start indicating whether they want amendments, and then Dáil Committee is where we end up with the really detailed amendments required. Sorry, my phone, I didn't turn it off. So Dáil report stage was December 2022. Again, it just provides for further scrutiny of the bill. And there was a resumed report stage in February 2023 to take account of the structural changes to do with the Part 5 reviews of patient-requested reviews of cancer screening. Really then, at that stage, ultimately, a lot of the scrutiny and amendments which were going to be done, and agreed amendments, were finalised ultimately by Dáil report stage. So when it went into the Seanad, there was just a consensus that broke out really within the Oireachtas that it was brought to the final stage that they wanted that, and it was agreed that the text as agreed was fine. So Seanad then was pretty quick with March 2023 and then April 2023. And then it was submitted from presidential signature on the Tuesday, the 2nd of May, 2023, which then made it enacted. So it lies there on the list of acts enacted by the Oireachtas and ultimately ready for commencement. We'll talk again about that later on. So I'm going to stop talking here and hand you over to Susan, who's going to just talk to you about some of the more important amendments that took place at the time. And thank you.
Hi Liam, hi everybody. Thanks again for giving us this opportunity to talk to you about the bill. My name, as you know, is Susan Riley. I've been working in the patient safety area of the Department of Health for quite a few years now. And Angela, I think it's fair to say that we go back a long way since the introduction of the first HSE open disclosure policy in 2013. So look, thanks a million, Liam, for the very detailed outline of the legislative road to the Dáil. I'm going to just give a little bit more context about the important amendments to the Act, which were, as Liam said, introduced at committee and report stages. So I suppose we've three on there, but actually I'll just go back a little bit to the committee stage. When the bill passed through second stage in the Dáil in December 2019, it was agreed at that stage that there would be three amendments brought at committee stage. And one of these was an amendment to Section 9 of the Health Act 2007. And this was actually to clarify and strengthen relevant ministers' powers. That would be our minister, and equally the minister with the very long name. It's children, equality, integration, everything. And it would give them extra powers to request an investigation by HIQA into the health and social services here. And the second amendment, it sought to expand the provisions of bill. This would be our section 12 of our bill regarding openness and transparency, and it was to apply more widely in the in relation to patient safety incidents in the health service. So this section would obliges regulatory bodies, HSE, HIQA, to provide for openness and transparency in the performance of their functions and also in their codes and or standards of professional practice. And the third amendment at committee stage was pretty much an amendment, and that was to align the open disclosure provisions within the Civil Liability Amendment Act, Part 4, which Liam mentioned earlier, with the provisions of this Patient Safety Act. And in particular, there was to be specific reference to the organisation of the open disclosure meeting, the provision of information to the patient and the family, their families, and the procedures to follow in the open disclosure meetings. And this was just to ensure that the same procedures would be carried forward, you know, from the 2017 Act to our Act. There's no other substantive amendments or any changes to the 2017 Act. So, okay, we'll go on now to the amendments at report stages in the Dáil. So the first one there, it's a review of the Act mechanism, and that's a pretty standard feature in all pieces of legislation. The second one, screening, which is the open disclosure of patient requested screening reviews. And then the third one was the nursing home incident review. So if you go on to the next slide, Maurice, please, I'll go into a bit more detail. So the review of the Act mechanism, as I said, it's a pretty standard section or provision in each piece of legislation. In this case, it's section 80 of our Act, and it provides that the Minister shall, again, the compulsory there, initiate a review of the operation of the Act no later than 2 years from the date of commencement. And 2 years is required, and that's to allow sufficient time for the provisions of the Act to become embedded within the health sector. And it also allows for initial learnings, you know, to be assimilated from the experience of the various organisations who are carrying out the implementation. Some of you might be familiar with legislation and know that kind of the standard review period is 3 years generally, but there was a lot of debate about this at report stages, and it was agreed that it would be a 2-year period. So the amendment also makes provision for the Minister to consult widely when carrying out this review, and he or she can engage with any person, body or organisation including other ministers in the government, you know, whose work or functions might have some kind of impact on this act. And it's just basically to give, I suppose, you know, a robust basis for ensuring that reviews are carried out extensively and widely. And the scope of the review, it is just on the operation of the Act through the health sector, not various pieces or sections of the Act. So next slide, please. Okay, so we come to screening, and again, I think a lot of you might be wondering why screening is included in the bill, and if any of you were following the, you know, the debates at committee stage and in report stage, you will, you know, you could be forgiven for thinking that this bill was primarily about screening and particularly, you know, relating to cervical check. So the minister was very, very much behind this amendment, and I suppose he believed that, you know, it was important to include something relating to open disclosure around screening. Now, it's important to bear in mind, it's not just cervical check, it applies to the three current screening services as operated by the National Screening Service. So he did flag this amendment at committee stage and that he was going to introduce it at report stage, and this would be to provide for a mandatory open disclosure of completed individual patient requested reviews of their cancer screening by the Health Service National Screening Service. So the new amendment provides patients with the full assurance that should they patient requested review of their screening be completed, the full disclosure of the results of that review will be legally mandated regardless of what the result is. Okay. So, I mean, there was a lot of discussion about this. You know, we toyed with the whole how we would set it out in legislation, etc. But ultimately, as we say here on the next slide here, this is what we introduced at report stage. So a part 5 patient requested review, that's because it's in part 5 of the Act, hence the part 5. So it's a review, as I said, in respect of cervical check, breast check, and bowel screening program. This was included, okay, in section 5 of our Act. So this review is going to be subject to mandatory open disclosure of all the relevant information related to that part 5 patient requested review in a similar manner to the notifiable patient safety incidents elsewhere in the Act. These are the notifiable patient safety incidents that are listed in Schedule 1 to our Act. So there was a huge amount of debate. I think, as Liam said earlier, there was a lot of the heavy lifting was on this Act was done in the two Doyle report stages. The first one, which went on for 4 hours in December 2022, and then the second one, I think it was the 15th of February this year, which it did go on for some 2 hours, but I think the fact that we had gone back, you know, between the two reports, the two time frames, and, you know, reviewed the screening provision, listened to all the interest parties, and came back then with this solution. I think this very much laid the groundwork for the rest of the bill progressing very quickly through Shannon. So basically, during that period between December and February, another amendment was prepared to ensure that the health service provider shall inform the patient of their right to a Part 5 review before or at the time the cancer screening is carried out. Again, there was a little bit more discussion about this at report stage. You know, a lot of the opposition felt, well, sometimes if a person is undergoing screening, fine, they'll be told this, but, you know, it goes in, we're all guilty of it, it goes in one ear and goes out the other. And then say somebody subsequently is diagnosed with cancer, you know, the shock of that and trying to come to terms with whatever treatment that you might have to go through. Again, you know, your right to request a patient requested review wouldn't be necessarily at the top of your agenda. So we also provided a piece that the health service provider is required to establish and implement procedures for the further provision of information to patients with regard to their right to make a request for a review. So basically, you know, people would have to be maybe given a reminder, you know, the next time they go for a screening, and, you know, there'd be a website, and these procedures would be drawn up, I suppose, in consultation with, you know, the patients and various patient groups. So next screen, please. So in summary, the new screening amendment, which, you know, if any of you have looked at the Act, you'll be going, wow, there's 20 something sections or whatever. It seems, you know, really lengthy. It's actually not. It's fundamentally 35, section 35 and 36 are setting the basis for the patient requested review. The remaining sections, they're actually replications of the open disclosure provisions that apply to notifiable patient safety incidents. The same provisions had to be replicated to provide for mandatory open disclosure of patient requested screening reviews. So that's why there's such a huge, you know, kind of chunk of new sections, what appear to be new sections in the Act. So to summarise then, the new patient requested review, it was developed for cancer screening following the guidelines from the expert reference groups, which you may remember were published, I think, in October 2020. And in the case of cervical check, they were designed in conjunction with patients, including the 221 plus group. It's going to be mandatory to fully disclose the results of the reviews to patients. Before the patient participates in the screening program or has a test, the legislation provides that they, you know, have to be fully informed that reviews are available in the future. And finally, as I think this is an important piece as well, the choice of whether or not to get a review is very much for the patients to decide. It is apparent, and from working with our colleagues in population health, that not all patients want a review, that is their personal individual choice. And the patient, but however, has to be, you know, empowered to make an informed choice. So next screen, please. Next slide, sorry. So again, you might be saying, why have we got a review of a nursing home incident in our Patient Safety Bill Act? As Liam said, sometimes when you're working on legislation, if something has to be done urgently, the fact that your legislation is open, that gives your colleagues kind of an opportunity to introduce their particular amendment, etc. So, okay, what we did in the Act then, this gives HICWA, the Chief Inspector of Social Services, so a discretionary power. This is to carry out a review of certain incidents, and it's just, I suppose it's really in relation to incidents where some or all of the care of the patient was carried out in a nursing home. Okay, so they may have been in a nursing home and then maybe moved into, an acute hospital setting or a HSE, say, care of the older person's home, nursing home. But it's just to take into account care that they did get in a nursing home. So the amendment, it allows for, I suppose, the implementation of in a timely manner. There was a recommendation in the report of the COVID-19 nursing home expert panel that the Department of Health should look and explore a suitable structure and process for external oversight of individual care concerns arising in nursing homes, you know, once all the internal processes have been exhausted. But it doesn't replace the responsibility of the nursing home services to address concerns that have been raised by patients and their families. But it's just to put in place some kind of a pathway to ensure, you know, the concerns are addressed that will provide answers to families and patients when something has gone wrong. So next slide, please. Just looking there, so then I'm not sure whether it's coming up. Yeah, so okay, Bill's office, Whip's office, proofing, what have they got to do with legislation? These are just to give you an idea. The Bill's office, they're the civil servants who actually process all the legislation that's going through the various stages in either the Dáil or the Seanad. They are a huge resource to any person who's developing legislation because they really know their business, and I'm not sure we could have got through the process without them. So basically they get in all the amendments, everything like that. There's quite tight timelines as well, you know, in the Dáil. The opposition can put in an amendment. They have to be received 4 working days before the report stage or committee stage takes place. You know, there can be quite a lot of amendments put down, and you know, it takes quite a lot of time and effort to turn them around in the time allocated to us, and to make sure, you know, that we have checked everything carefully. Again, the whip's office, they are kind of private secretaries, again, civil servants. So there'd be somebody working with the chief whip to government, and there'd be another person who's working chief whip to the Seanad. So they very much, give us dates and allocate us our dates, allocate us our times, etc. For instance, just going back to the initial report stage, usually, a session might be 2 hours or something like that. And then there's a guillotine where they just vote in the end. In that case, we, had a 4-hour session. There was no guillotine. I mean, it could possibly have gone on much longer than it did, but, this is where they come in and they manage all that. And then the final thing here is proofing. I know loads of you are involved in, is it policies, procedures, protocols, PPGs, guidelines, everything like that. And you all know the pain that comes with proofreading very detailed documents and, watching for every I, T and commas, semicolon, everything like that. So that's pretty much just to give you an idea of kind of the other work that goes into producing this act. So, okay, we're nearly coming to the end. So next slide, please. Right, so the next steps, this is probably what you're all most interested in. So I might just skip down through the first 2 bullet points there. So there's a commencement timeline. As Liam said, the Patient Safety Act, it was enacted on the 2nd of May. There's a lot of preparatory steps required here before we commence the act. Some acts are commenced pretty much immediately, but in this case, there needs to be a little bit of time here to get it up and running. So we do intend, however, to commence the act at the earliest possible date, and we will provide, as a department, practical guidance as soon as matters develop. So already in progress, there's significant multi-stakeholder engagement. Also yourselves, the HSE, there's a KPI development group and a HSE implementation group. So one of my colleagues is a member of Workstream 1 of the National Open Disclosure Performance Measurement Project, and that is actually working on the development of the KPI for open disclosure for the HSE service plan. And the director of the NPSO is going to attend the next meeting of the HSE implementation group. Then just popping back up to the first 2 bullet points there is a project manager has been identified for the NIMS notification project. Part of the bill requires that, the notifiable incidents are notified to the relevant regulator and, either HICWA or the mental health provision. There is there's procedure that just has to be updated or devised for the NIMS current system to enable this. So we have had interviews and a successful candidate has been identified for the project manager, but we're just waiting on a start date. So next slide, please. That's really it. So listen, I'd like to thank you very much for giving us this time to let you in on the Patient Safety Act and how we got there and all the bits and pieces that go with creating legislation and actually getting it through successfully through the houses of the Oireachtas. So I just have put a link there for the actual act, and that's on the Oireachtas website. It's actually it's a good website as well because it gives the debates at the various stages, everything like that. So you could, if you wished, just dip in and out of pieces if you were looking for a particular amendment or something like that that was introduced. So look, I'm conscious I've taken up a good bit of time there, so I'll hand over now to Arnell and Stephen. Thanks again.
Thank you, Susan. Good morning, everybody. My name is Arnel Kidpalos, and I'm one of the principal officers working in the National Patient Safety Office of the Department of Health. So we're now going to present to you the National Open Disclosure Framework, and I'm going to do this with my colleague, Stephen Dredge. So just to give you a bit of background on the development of the National Open Disclosure Framework. So the Department of Health developed the National Open Disclosure Framework with the intention of providing a policy that will provide a consistent and unified approach to open disclosure in the private and public healthcare services here in Ireland. This will also include the participation of professional regulators, for example, NIMBY and the Medical Council, and of course the other regulators as well, and also service regulators such as HICWA, the Mental Health Commission, and the higher education institutions that are providing programs or courses with clinical components, and also other relevant bodies and organizations. So the development of the framework was recommended by the Independent Patient Safety Council, which was appointed by the minister in 2019, the Minister for Health, Simon Harris. And their initial focus with regards to the work, is the development of recommendations in respect of a national policy framework on open disclosure in health and social care. So after the appointment of the members of the council, the Department of Health then seek the service of the CRO. CRO is a consultancy firm, and basically what we did is we asked them to conduct a research on open disclosure. So they did that in 2020, and in 2021 they came up with the report, and this report now provided the evidence base that informed the council's recommendation and the development and implementation of the framework. So with the report, then the council made the recommendations to the Minister for Health, and this recommendation also provided the roadmap for the development and implementation of the framework for different stakeholders. So the recommendations then became the 6 principles of open disclosure that you can find in the policy framework. It's on chapter 3. Next slide there, please. So while we were developing the National Open Disclosure Framework, we went and looked at existing policy on open disclosure, and we have we found the HSE open disclosure policy, which is a very good policy, and as Liam has stated earlier, that this has actually laid the grounds for open disclosure in the healthcare services. And what we did is we used this as our main resource in the development of the framework. The policy was first launched in 2013, and then it was revised in 2019, and it's going to be updated again after the framework is going to be published at the end of the summer. So the Independent Patient Safety Council also recognized and acknowledged the work of the HSE in developing a culture of and commitment to open disclosure and practice, and the framework is built on this foundation. Let me just point out to you guys that the policy only covers the HSE and HSE funded organizations. So when we were developing the framework, we also look at other organizations outside the HSE and HSE funded organizations with regards to their existing open disclosure policy, and a lot of these organizations, they don't have this policy. Next slide, please. Now we have the Patient Safety Notifiable Incidents and Open Disclosure Act of 2023. I'm not going to go into it, as it's already been discussed by my colleague Liam and Susan. I just wanted to point it out to you that this act only covers specified incidents in terms of open disclosure. Now we have the National Open Disclosure Framework. And again, basically the aim is to provide a unified and consistent approach to open disclosure across public and health, private health and social care services, service providers, service regulators, health and social care professional regulators, health and social care educators, and other relevant bodies and organizations. So you can see there that everybody is included in it. The framework intends to make an open disclosure the norm, not merely the focus of mandatory disclosure. Basically, what we want to see happen is that that open disclosure is basically an integrated part of the services that's being provided by service providers and in the practice of all the health and social care professionals, keeping the focus on the concepts of humanity, empathy, and open communication, and recognizing the importance of the timeliness of the first early communications in reducing any further possible harm or trauma. And basically if something happens in the care of, or something wrong happens in the care of a patient or service user, what they want to know is, why did it happen? What are you doing as a service provider and healthcare professionals to ensure that it's not going to happen again in the future? And how are you ensuring that they're receiving the proper care in that particular time? Next slide, please. So after we developed the draft National Open Disclosure Framework, we conducted consultations in 2022. So we did that on Q1 and Q2 of 2022, and we did it in 2 phases. So first phase would be, we did a focus consultation with relevant stakeholders. So these relevant stakeholders are service providers, professional regulators, and service regulators. And basically, our aim is to sense check the provisions of the policy. And then, so after we completed the focus consultation, we went back to the drawing board. We considered all the feedback that we received from that consultation, and we looked at the policy again, updated it, and then we conducted a public consultation. So we did this in the Q2 of 2022. So overall, the result of the public consultation is very positive, and you can see there that there's some results with regards to the feedback. I'm just going to read it out to you guys. So the result of the public consultation on the framework showed that 97% of the respondents are in favor of an open disclosure policy to be in place in all health and social care services in Ireland. So just remember that at the initial development of the framework, went looking for existing policy, and there's not a lot of organizations who have this policy outside the HSE and HSE funded organizations. And second result there is 97% of the respondents to the public consultation either agree or strongly agree that organizations should promote a just culture. So remember earlier that Morris was talking about the importance of moving into just culture, okay, and basically abandoning blame culture. Okay, so I am going to pass it now to my colleague Stephen Dredge to talk about the different parts of the open disclosure framework. Thank you.
Hi, everyone. Thanks, Arnell, for that introduction. And my name's Stephen Dredge. I've worked under Morris's team for the last 2.5 years on the development of the legislation and the open disclosure framework. So it's great to be here today to talk to you all. I hope you can all see and hear me, but if you can't, Angela or one of the team might just prompt me. So I'm going to just take you through a whistle-stop tour of the 7 chapters in the open disclosure framework. Starting with chapter 1, so it's basically a short introductory chapter which sets out some of the concepts and definitions around open disclosure, patient safety incidents, and what we mean by adverse events. Chapter 2 then develops on the context further in terms of the legislation and policy. So it sets out the various roles of key organizations involved in the implementation of the framework. It looks at national policy and legislation, so looking at the Patient Safety Act, the implications of that, and the HSE open disclosure policy and the good work that has been going on in the health service with that since 2013. And then we also talk about the international context and various legislation and policy that have informed the development of this framework. Moving on to chapter 3 then are the principles of open disclosure, and Arnell will have mentioned there the Independent Patient Safety Council of the Minister for Health. Their recommendations heavily informed this framework, and they were developed around these 6 principles which are highlighted in the blue text. So open and honest, compassionate and timely communication, patient service user and support persons' entitlements in open disclosure, supporting health and social care staff, promoting a culture of open disclosure for improving health and social care policy and practice, and the importance of good clinical and corporate governance for open disclosure. So really, like, they're all very much centered around that key one in the middle there, promoting a culture of open disclosure and building on the good culture that exists already. Next slide, please. Chapter 4, then, this is probably the most relevant one, I suppose, for health services providers and the open disclosure process, and various entitlements that patient service users and families have in open disclosure. So one of the key things here, I suppose, is that health and social care service providers must have a policy on open disclosure in place that aligns with the provisions of the framework. So the framework sets out the key elements that should be in every policy, and then it'll be up to relevant health service providers to adapt their policies based on the framework to their local context. Then health and social care service providers must also include mechanisms in their open disclosure policies empowering staff to report patient safety incidents and adverse events and communicate with patients and service users and their support persons openly in relation to these incidents. So again, it's just it'll be up to each service provider to develop these mechanisms and adapt the framework to their local context. So it's not 100% reinventing the wheel. The HSE have a policy in place already, but once the framework is introduced, they will be required to update that policy based on the framework. So next slide, please. So chapter 5, then, this is the chapter that, so we talk about the different organizations that are involved, the non-health service providers, so health and social care regulators, and the various different organizations here, they all have different functions. So what the framework will be asking them to do, it depends on those functions. So service regulators will be asked to embed the principles of open disclosure into their standards and guidelines for health and social care services, and ensure that inspections of services assess compliance with the framework. Professional regulators then will be required to include open disclosure in all policies and codes of conduct, ensure open disclosure policy in all education bodies and training sites are in place, and embedding of the open disclosure framework in all approved undergraduate and postgraduate education and training with a clinical component, and approval of professional development courses on open disclosure. Next slide, please. Finally, then, in chapter 5 is the education bodies. So they'll be required to embed open disclosure in all their undergraduate and postgraduate education and training programs with a clinical component, ensure that all sites for clinical and practice placements have a policy on open disclosure in place. So this is obviously another important part of embedding this and improving the culture of open disclosure in the health service. And that's just another statistic from our public consultation last year. So you can see there the broad majority, 95% there, agree that open disclosure should be embedded in undergraduate and postgraduate training programs. Next slide, please. Chapter 6 then is the drivers for the culture change that is required. So these arose out of the principles of open disclosure and recommendations of the Independent Patient Safety Council. And so they are learning and continuous improvement. So learning from open disclosures and changes in policy and practice that occur from that. Communication, engagement, and feedback. So engagement with patients, their families, and service users and staff on their experiences of open disclosure. Leadership, and I suppose that's self-explanatory, but I suppose leadership across managerial grades, clinical grades, and at all different levels of organizations. Training and development then as well. There's obviously good training going on in the HSE, but building on that and rolling it out to more people. Open disclosure champions then as well. So people that will champion the policy throughout the services. The graph at the bottom here is just out of our public consultation, and we asked people to rate the various drivers. So you can see everyone believes that they're all relatively as important as each other, with a slight preference there for leadership and communication, engagement, and feedback being slightly more important. Next slide, please. Finally then, chapter 7, chapter, so it's monitoring and evaluation of the framework, and so looking at how we're going to measure the culture change. So we'll be asking key organisations to submit an annual report to the Minister for Health on how they are complying with the requirements of the framework. So each different type of organisation, so whether you're a health service provider or a regulator, etc., they'll have various reporting requirements. So for example, here for health service providers, they'll be asked for the development and implementation of open disclosure policy, to report on the development and implementation of open disclosure training, evidence of availability of support structures for staff, the number of trained staff, number of appointed and trained clinical and managerial champions, and the number of open disclosure events initiated and closed. Next slide, please. And just to wrap it up then, our team's current focus and next steps, we'll be looking to publish the framework and circulate it to all relevant stakeholders. We're planning to have a launch at the end of the summer when everyone's back from holidays and bits like that. And we'll be doing this in collaboration with the HSE and other key stakeholders, and outlining the obligations that are on various organisations to help with implementing the framework. And just to finish off there with another stat from our public consultation, that 95% of organisations agree that it's important to promote the open disclosure framework. So I think everyone agrees that it's an important piece of policy to implement. There's good work that's already happened, and the HSE have a great policy in place, but it's just building on that change in culture that's already started. So I might wrap it up there, and I think we're open for questions now, but I'll just hand you back to Angela just to say where we'll go from here. Thank you.
Okay, I think Morris wanted to just do a bit of a wrap up there for yourself, Morris, is that correct?
Thanks very much, Angela. I'm aware of the fact that there's a huge amount of information that we've just kind of put out there, and all of that information will be available. The slides, I think Angela and the team are going to make available to everybody afterwards. But just in the interest of timing, maybe it's best to move straight to the Q&A at this point. If there's, I saw some questions kind of coming in the chat box as we're going along. The broad overarching thing that I can say is that the Patient Safety Act applies to the entirety of the health sector. There are some questions, does it apply to particular parts, mental health, etc.? It applies to the entirety of the health sector. Some parts of it, some of the specified incidents are probably more relevant to the acute sector, given the nature of them, but the provisions of the bill apply to the entirety of the health and social care sector. So I saw that one come up a couple of times, but Angela, I know you've probably been kind of gathering together a few questions as well.
Yes, so if the team, the panel would like to turn the cameras on, maybe I think you've covered it. Most of the questions relate to, you know, does the framework and does the legislation relate to all services? And one of the questions there was, how does this legislation relate to pilot studies for new screening services? I know we've got the 3 screening services within the current legislation. So is there any plans for it to extend to new screening services or other screening services?
Yes and no would be the answer to that. The bill is quite specifically refers to the cancer screening services which are in existence at the moment. Now, if that program changes, if there's new screening programs brought on, the legislation can be amended to include those. It's certainly the policy intention that any cancer screening service would have the same level of review available and open disclosure available. That's a matter really for the National Screening Service and for everybody else. But if those new screening services come online, certainly we will be looking to adapt the legislation to provide these protections to those new services as well.
And of course, everything that isn't covered within the notifiable instance within the patient safety bill, it answers some of the other questions as well here, is falls into the remit of the open disclosure policy, which requires that we report and disclose all patient safety incidents, and particularly where there's been harm to a patient. So I think that will address some of the other questions that are in there that fall out of the scope of the notifiable instance within the patient safety bill. Would you agree with that, Maurice?
Yeah, exactly. As I said at the start, Angela, it's kind of two sides of the same coin. There's the legislative side of things, which is when it comes to mandatory open disclosure, that's the sharp end of the stick. This is what absolutely has to happen in law. Here's who's responsible. Here's what the penalty is if you don't do it. But as you said, the open disclosure policy, for example, the excellent HSE open disclosure policy, covers all of the other types of events anyway, and sets out how those should be reported and the open disclosure that should take place for them. So it's kind of two complementary sides of the same process, ideally.
And just a couple of questions just directed for yourself there, Maurice. What is the typical time period between enactment and commencement stages?
It varies completely, to be honest. It never takes place straight away, as much as politicians would like it to do. As soon as it comes through the door, it's done. For example, the Assisted Decision Making Act of 2015 that was revised, and just all final parts of it commenced this year. So there can be that kind of a time lag. Our intention is to get this up and running as soon as possible. There's two sides to what needs to be done. There is a practical legal side, which is that the NIM system needs to be modified to allow for the notifications of these incidents, which is a central part of the bill. The second part, as important, is the training and communication and so on that needs to happen around the provisions of the bill. Yeah, it will be done as soon as possible. I think the original question was, is there a standard kind of timeline?
Yeah.
There's not really. It does depend, but it can vary from kind of 6 months after enactment to a much longer time frame. We're not aiming for the much longer time frame.
Okay, I'm conscious, Maurice, you're going to another meeting, but maybe just one last question maybe for you.
Yeah.
Will the Act prevent the previous cervical screening issues occurring in the future?
It's a good question. I mean, one of the dangers of the way that this legislation has developed is that people have honed in on the cervical check and the screening stuff. The bill is about a lot more than that, and it was always intended that it would be. What it provides for, it's based on the recommendations of the expert reference groups into cancer screening. It provides for the full open disclosure of the new type of review that will happen. So these patient requested reviews, if a person has had a screening, subsequently develops a cancer, they can request a review of the screening. What our bill says, what our Act says, is there has to be full open disclosure of all elements of that review. So if the review happens, the patient has to be told every aspect of it, even if there's nothing in the review or whatever the outcome may be. So in that sense, yeah, it facilitates the open disclosure of a new system. So what happened previously should never happen again with the new system being set up by the screening service.
Okay, thank you very much, Maurice. And just maybe over to Orla or Lorraine, really, in relation to what are the next steps for the HSE now in relation to the implementation approach to the patient safety bill? What kind of work can we see coming down the line for? I think you're on mute, Orla. You're on mute, Orla, there.
Apologies, I was having technical problems with my mouse. Yeah, so we thanks very much, Angela. We've established an implementation working group, and that group is meeting for the first time this afternoon. So the terms of reference for that group and a high-level implementation plan have been drafted, which we expect to present to the to our colleagues in the department very shortly, and we will be progressing to work on our side of the implementation, and very quickly. There's already a high-level group in place with the department and states claims that have been progressing, and the work outside of the HSE. So yeah, and we acknowledge the fact that there will be a resource requirement associated with that, and the business case for that is being prepared as well. And I should have said that there's pretty broad representation on that group, so all of the areas that are affected within the health service will be included. So we've representatives from audit, from screening, from yourselves from open disclosure, incident management. Lorraine might want to add.
It's just a question there, Orla, that relates to what you're saying there, just from could somebody from Section 38 Disability Service be involved in the implementation group?
Actually, we're reviewing the terms of reference and the membership this afternoon at our first meeting, so we'll take that point on board.
Thanks, Orla. And Lorraine, is there anything you want to add to that?
And obviously we've reached out to our operational colleagues, so there is representation from operations from the QPS side of things, but there'll be the high level implementation groups, but we're planning on setting up a number of work streams. So again, we'd be grateful of input and support from the wider system. So areas we'll be looking at are obviously around the governance arrangements in terms of managing the implementation of project plan, reviewing our policy so that it aligns with the legislation as well as the National Open Disclosure Policy Framework. We are working with legal colleagues in terms of the legal interpretation of some of those specific requirements. And as Orla mentioned, obviously can develop the business case and engage with colleagues in terms of needs to facilitate the implementation. And then we are looking at the technical requirements, in terms of the reporting to our regulators from the NIM system to improve how we capture reporting on the NIM system, but also to look at some of the turnaround times within our system, and because there will be specific requirements, we need to report to HICWA and that within 7 days, and just to understand how we're meeting that, or how we would be, what we'll be achieving against that. And then there'll be screening, clinical audit, and Angela and team will be very much leading that on the resource development, training and education programs. And we'll have a whole comms and engagement strategy to support that, and work with colleagues out in the system in terms of the operational implementation.
And Lorraine, just a question here as well, is there a timeline for updating the 2017 SRE list and guidance?
Thanks, that's a great question. And I know it was muted before, and an expectation that with the notifiable incident list that would possibly replace the SRE list, but we know obviously they're quite different in terms of the level of harm associated with it. So the initial focus will be on the implementation of the legislation and the notifiable incidents, and then doing some work with the department and other colleagues as well to review the SRE list, because I know that was a big piece of work a number of years ago, but that will follow soon after. So that is a good point to build into our plans. Thank you.
Okay, and just another question there in respect of the Part 5 reviews. Is there a defined process to guide local clinical teams and patients wishing to access these reviews?
Will I take that? Orla, you might.
Yeah, no, I'm not sure if our colleagues from screening are on the call, but there's following those expert reference group reports, each cancer screening program put in place implementation groups to work through all of those processes. So that's been worked through by our colleagues in screening.
Yeah, there'll be lots of comms around that for our colleagues in the system. Yeah, they're quite active in it.
Yeah, I might just come in on that as well, just in terms of the legislation. So the legislation is quite clear in what it covers, and it covers the open disclosure once these reviews have taken place, but the mechanics of the reviews, set up are for the screening service, the individual screening services and the broader national screening service to determine and set out. And I know a lot of work is ongoing in that, involving patient groups and so on, with the full design of that. So it's outside, the nature of the reviews is outside the scope of the legislation, but I'm very aware that a lot of work is being done on that.
That has progressed quite a lot since since those ERG reports were published during the pandemic.
I know from our work with the cervical screening group that the extensive work's been done here in relation to, procedures and guidance, and work around the management of the meetings with the patient request reviews as well, and training staff in the delivery of the results of patient request reviews also. So there's a question here just around, and I can answer this one myself, around the review of current open disclosure training to include the new legislation. So we will be looking at all of our training, from our online e-learning modules to our face-to-face training. And I'm sure everybody on the call is aware that we have been including information on the Patient Safety Bill now since 2018, and updating that information as new information has become available. We also will be doing new training as well, just more detailed training on the whole bill, and particularly the process for managing open disclosure, from the preparation of the meeting to manage the meeting to the delegation of the designated person, which we see as a very welcome part of the legislation, and kind of enhancing that role of the designated person and supporting patients and families involved in patient safety instance. We'll also be delivering some training on the role of the designated person as well. So a lot more training coming down the line, and certainly a review of all of our training is happening at the moment, and also our resources as well. I don't know if there's any other questions there at the moment. I don't know if anybody has any additional comments to add at all, or...
Angela, I did see one popping up there in the chat box a little while ago, which is a very good and relevant question. It asked about nursing homes, the provisions of the bill for nursing homes. Given that most nursing homes were private, how does that work? I could give a very quick answer on that. But the overall bill covers all parts of the health sector, whether private or public. So all of the provisions around open disclosure, etc., all of those things apply right across the board. The specific section of the bill about reviews of incidents in nursing homes, that only applies to nursing homes. For reasons of expediency, was brought in just to apply to nursing homes, but it applies to all nursing homes equally. In the law, there is no distinction between a public and a private nursing home. So that the provisions there about reviews apply absolutely equally to public and private nursing homes.
Okay, thanks for that, Boris. I just want to hear, will the Act protect people with dementia who may have additional confusion due to infection, dehydration or pain, leading to refusal of medical treatment, or walking out of a busy A&E department in a confused state?
Outside the scope of this bill, unfortunately, I think you're going into kind of safeguarding territory and a number of other territories. You're touching on the Assisted Decision Making Act. It's very important stuff, but not the stuff which is covered by this bill as such, for the most part.
And I suppose as part of that, anything in that scenario there where the patient safety incident identified would fall into the remit of the open disclosure policy anyway. So, and I suppose for myself, an important thing for me is that whereas the Patient Safety Act relates to a defined list of these notifiable incidents, that it's important to remember that, you know, we have an open disclosure policy which relates to all patient safety incidents and the need to open disclosure around those incidents. So it's important to know it just as a matter of risk management here, that we don't forget about the importance of all other patient safety incidents outside of the Act as well.
That's a good point to end on, Angela. Well done.
Okay. So it's just to thank you all again, and I'll just bring up some of our closing slides. Thank you, Maurice, to the whole team for your time today, and you've pulled this together in very short notice, so we really appreciate that. I think it's very timely. It's a good kind of kickoff for the HSE implementation plan now around open disclosure. Orla, do you want to add anything yourself there?
Go for trouble. No, I don't. No, we look forward to working with you now to bring this to fruition. So thank you all very much for your participation and your attention.
Thank you, Orla. So just finish off into some of our closing slides now, and just to remind people of the requirement to attend open disclosure training. So open disclosure training is mandatory for all staff working in HSE and HSE funded services, with requirement for all staff to complete Module 1, Communicating Effectively Through Open Disclosure, which is available on HSE Land, and all of our modules are CPD accredited. For staff who may have to engage in the higher level open disclosure meetings, and they also need to complete e-learning Module 2 and also attend face-to-face skills training. So Module 2 is also on HSE Land, applying principles to practice, and again CPD accredited, and also to attend face-to-face training. And to access face-to-face training, there are HSE leads, open disclosure leads in all HSE areas. So just contact the lead for your area, and the names of all those leads are on our open disclosure website, and they will organise that training for you. There are also trainers in every HSE area as well who deliver this training. Just to maybe highlight some future webinars, so just keeping the theme of the Patient Safety Bill, our next webinar next month is going to be on the role of the designated person in incident management and open disclosure, and that's on the 12th of July at 11 AM. And then for our autumn schedule, we have a webinar on the 13th of September on managing conflict by Professor Eva Doherty in the RCSI, and will also be rescheduling our restorative practice webinar, which was due this month but had to be delayed for a short period due to just situations outside of our control. So we look forward to that webinar in perhaps October or November. And just in relation to our webinars, we do listen to your feedback, and it's very important that you give your feedback to us. So we will be sending out a short email, and the email will include a copy of today's presentation. As I said, the recording will be on the website. There will be a link as well to an evaluation, just of your experience of today's webinar, and also to give you an opportunity to give us examples of other webinars or topics that you'd like us to deliver for you. I'd like to thank our ISL interpreter today it's a long time, it's over an hour to be doing the sign language. So thank you very much, Lisa, for doing that for us. And just to thank you all again for attending our webinars, with over 400 people again here today. So it's a great commitment from you in our services, and we look forward to seeing you next month. So thank you, everybody.
Thanks very much.
Thanks, Marion.
We can move people into practice if you want, Sandra.